Today we're going to talk about Grimard v. Canada in the Federal Court of Appeals in 2009, and this is a broad look at how the Civil Code of Quebec integrates into the rest of Canada and how these conflicts are determined in the court. On the outside, this is a contract case taking a look at whether employment was a service or whether it was employment. Okay, let's take a look at the background here. So this case is being appealed here by the appellant who offers services as a consultant in environmental health matters. So he works as a medical assessor with the CLP in Quebec. And he was reporting that income as professional income, like you would if you were an independent contractor or a service provider. So he was deducting expenses, especially for his personal travel between his house in Sherbrooke and his house in Montreal. So the Quebec Ministry of Revenue determined that the assessors at the CLP had the status of employees. This is after like 4 years of work. So this determination resulted in an income tax adjustment and basically meant that he owed some money. So he appealed, and the court rendered its judgment by which it upheld the decision of the Ministry of Revenue, and basically said that the appellant was in fact an employee based on the criteria of control, ownership of tools, chance of profit, risk of loss, and integration into the business, which are technically common law factors, but there's a lot of overlap with the civil code. So the appellant appealed, it was upheld, and now he's appealing again to the Federal Court of Appeals. And they're saying basically that the trial court correctly assessed and this appeal is dismissed, but they will then state why. So some of the rules extracted from this case, both the common law and the civil law, are equally authoritative and recognized sources of the law of property and civil rights in Canada. Now, note that this is a federal law that is stating this, so this isn't from a court case. The common intention of the parties, rather than adherence to the literal meaning of the words, shall be sought in interpreting a contract. That's from the Civil Code of Quebec. In interpreting a contract, the nature of the contract, the circumstances in which it was formed, the interpretation which has already been given to it, and usage, all that is taken into account. And a contract of employment is a contract by which a person, the employee, undertakes for such a period to do work for money according to the instructions and under the direction or control of another person, the employer, or in other words, subordination. And Civil Code of Quebec goes on to say a contract of enterprise or for services is a contract by which a person, the contractor, or the provider of services, as the case may be, undertakes to carry out physical or intellectual work for another person, the client, to provide a service for a price which the client binds himself to pay, which means that the contractor is free to choose the means of performing the contract, and there's no subordination rule there. I would note that this doesn't necessarily apply to quality and control or the outcome. That's been considered acceptable, which we will see a little bit later. The principle of complementarity Quebec civil law to federal law, when the conditions in section 8.1 are met, in so doing it allowed for differences in the treatment of Canadian litigants under federal legislation. And this is again going back to that Federal Interpretation Act. A couple more rules here. Behavior of the party in performing the contract must concretely reflect this mutual intention, or else it will just be based on facts and not claims. And third parties have an interest in ensuring that laws establishing payroll taxes for employers and employees are complied with, whereas one of the parties might try to avoid them normally. Okay. In Quebec's civil law, the notion of control is more than a mere criterion, as it is in common law. It is an essential characteristic of a contract of employment. This is from the D&J driveway case. Okay, so the analysis of the Federal Court of Appeals judge is putting here is really going along just affirming what the trial judge had originally said. And he's saying that the work relationship between the appellant and the CLP was that of an employer-employee governed under a contract of employment, and that the travel expenses, to his 2 different apartments couldn't be deducted in either case. In either case, that was a stretch to try to deduct those. He's saying there's no antinomy between the principles of Quebec civil law or common law. So basically saying that they're not necessarily in complete conflict with each other. So the criteria looked at here, the common law criteria, which is control, ownership of the tools, chance of profit, risk of loss, and integration of the worker into the business. So he's saying it's not necessarily that different from Quebec civil law, certainly not opposites. Quebec civil law defines the elements required for a contract of employment or for services to exist. Common law has factors or criteria, balancing tests, basically. The Civil Code says for a contract of employment to exist, the work must be under the direction or control of an employer, or in other words, subordination. A rule that comes from this case for future analysis, as part of this analysis, is that it must not be thought that these common law criteria are of no use, or that their use should be prohibited, or that such use would be heresy in characterizing a contract of employment under Quebec civil law. So that basically using balancing tests and factors to analyze things under the Quebec civil law is going to be acceptable from here on out. So under Quebec civil law, integration of a worker within a business is an indicator of supervision that would create subordination. So this federal court of appeal judge is asking, is that not the common law criteria? He also says it is the employer, not the employee, makes the profit and incurs the losses of the business, and the employer is liable for the employee's actions. Are these not also criteria for subordination in both the Quebec civil law as well as in common law? And then finally, the criterion of the ownership of work tools that is used by the common law, is that not also an indicator of supervision? So depending on the circumstances, it may reveal the degree of an employee's integration into the business, or his subordination or dependence on it. In a contract of employment, more often than not, the employer supplies the employees with the tools required to perform the work. So this judge goes on to say in both Quebec civil law, common law, that examine in isolation, that these points are not necessarily the concrete determinative factors. Then he's also saying it's really not that different, the criteria that's being used. And so, therefore, to analyze the control over work that is required under Quebec civil law, it is okay to use these common law criteria: ownership of the tools, chance of profit, risk of loss, and integration in the business. So he affirms what the trial judge says here. And the trial judge says, as the courts have stated many times, the fact that the parties characterize their contract as a contract for services does not necessarily mean that it is one. One must look at their conduct to determine the true nature of their contractual relationship. The judge went through these particular factors. Risk of loss, there wasn't any. Expenses are being reimbursed. He's covered by immunity from prosecution. It's employment, just like everybody else was saying. So Federal Court of Appeals says trial court correctly assessed, and this appeal was dismissed. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.